Hello, my name is Mark Joyce. I'm an attorney with Disability Rights Maine, Maine's protection and advocacy organization for individuals with disabilities. I'm here this morning with Kristin Aiello, who is also an attorney with Disability Rights Maine. Kristin is an attorney who specializes in voting cases. Good morning, Kristin. How are you?
Hi, Mark. I'm fine. Thank you.
Kristin, I'd like to ask you a few questions about voting rights for people with labels of mental illness.
Okay.
So last week in the newspaper, I read this particular article that said, "Notice of guardianship due to mental illness. A clerk must remove you from the voting list if they are given notice that you have been placed under guardianship due to mental illness." Is that right?
No, it is not.
But doesn't the Maine Constitution actually provide for that?
Yes, it does. But in 2001, the federal district court here in Maine, in a case brought by individuals under guardianship and Disability Rights Maine, found that this part of the Maine Constitution actually violates the United States Constitution. Therefore, no town in Maine can use that provision to deny someone the right to vote.
And you were the lawyer who brought that case, right?
Yes, I was the lawyer who brought that case, so I'm very familiar with the decision.
And are you holding the decision right there?
I am.
And does it actually say that this provision violates the Constitution of the United States?
It explicitly says that. The federal court stated, "The state's disenfranchisement of those persons under guardianship by reason of mental illness is unconstitutional."
Well, that seems pretty clear. And as I recall, wasn't the state of Maine actually implementing procedures that denied these individuals the right to vote?
Yes, they were.
And what did the court say about that?
Well, I'm glad you asked about that. The federal court found that what the state was doing was in violation of the Americans with Disabilities Act. The federal court said, "This court finds that in implementing its voting restriction, state defendants have violated Title II of the ADA and Section 504 of the Rehabilitation Act."
That's a very powerful opinion.
It is. There is no ambiguity.
And what did the Secretary of State do in response to that decision?
Well, they tried to get information out to the public and to municipal and town clerks so that no one would be denied the right to vote based upon this provision that had now been found to be in violation of the law.
Do you have any specific examples of what the Secretary of State's office did to clear this up?
Sure. Here's a current page from the Secretary of State's office training manual for election clerks. It reads, "On August 9th, 2001, U.S. District Court Judge George Z. Singal ruled that the language in Article 2, Section 1 of the Maine Constitution, which says accepting persons under guardianship for reason of mental illness violates both the Due Process Clause and the Equal Protection Clause of the United States Constitution and is therefore unconstitutional." Although the language still appears in the Maine Constitution, persons under guardianship for reasons of mental illness are no longer prohibited from registering and voting in Maine.
Well, that's good the training changed, but it does look like there's a long way to educating the public if in last week's newspaper it said, "Notice of guardianship due to mental illness. A clerk must remove you from the voting list if they are given notice that you have been placed under guardianship due to mental illness."
Right? It was shocking to see that article. And although the newspaper did issue a correction when we informed them of the mistake, it does concern me that on election day, some people still might wrongly believe that a person under guardianship because of mental illness can be lawfully denied the right to vote. I mean, this was a front page article.
Well, that's a good point, Kristin. So say a person goes to their polling place and they are told that because they're under guardianship, they will not be allowed to vote. What should they do?
Well, I would first suggest that they not argue. Rather, they should ask for a provisional ballot.
Provisional ballot? Is that different than a regular ballot?
No, it's not. It's the same exact ballot that everyone else is being given in your municipality.
So the person actually is given a ballot and they get to vote. So why is it called provisional?
It's called a provisional ballot because there's a process after the election to not have it count if, in fact, the person was not eligible to vote on election day.
But if the person was eligible to vote on election day, their vote would count.
Absolutely. This process is to make sure that people who are entitled to vote aren't denied the right to vote based on a mistake that was made on election day that can't be fixed after the election is over.
Like if a person under guardianship was not allowed to vote based upon a provision that had been found unconstitutional more than almost 20 years ago.
Exactly.
Okay. But what if the person's refused a provisional ballot?
Well, then they should contact Disability Rights Maine, who will be open during all hours the polls are open on election day.
Well, thank you, Kristin. I think you've really cleared up a lot of confusion that may have been caused by this article. And thank you all for watching our video. And information about how to contact Disability Rights Maine appears at the end of this video. Thank you.
Thank you.